Okay, a big win for the Burnham Law Firm Appellate Division today. The Court of Appeals announced its decision in re Marriage of Cerrone. Now, it's long been the law in Colorado that spousal maintenance, when it comes to spousal maintenance, that simply including the words or a provision, contractual and non-modifiable maintenance in a separation agreement, will render that maintenance essentially bulletproof. The statute at issue here is 1410-122-2A. That statute says that maintenance automatically terminates upon the recipient spouse's remarriage unless otherwise agreed in writing. So unless the parties agree in writing that maintenance will continue past the recipient spouse's remarriage. Under that statute, unless there's an agreement in writing, when the recipient spouse remarries, maintenance automatically terminates by operation of law. Now, for decades, courts in Colorado have held that simply including a non-modification provision, using the words contractual and non-modifiable, was such an express agreement, did mean that the parties agreed in writing that maintenance would survive the recipient spouse's remarriage. So in other words, until today, the mere presence of a non-modification clause has been sufficient to overcome the statutory presumption that maintenance terminates upon the recipient spouse's remarriage. The separation agreement in this case did have a non-modification provision, and although it said maintenance was contractual and non-modifiable by the court, it provided that maintenance was modifiable by operation of law. Now, we argued in this appeal that the cases interpreting 1410-122-2A were wrongly decided because that statute requires clear, express language rather than a mere implication that maintenance will survive remarriage. We also argued that even if those cases were not wrongly decided, even if they were correct, the separation agreement in our client's case was sufficiently distinguishable because of that by operation of law clause, a specific language in it. Now, the Court of Appeals adopted both of those arguments, declined to follow the previous cases, and held that any agreement in writing that maintenance survives the recipient spouse's remarriage has to be unmistakably clear. The court held that the terms contractual and non-modifiable are not talismanic words and that they're insufficient on their own to extend maintenance past the remarriage of the recipient spouse. To the contrary, it held that the language must be express and unmistakable in expressing any agreement that the maintenance obligation will survive the recipient spouse's remarriage. So after today, parties entering into a separation agreement must make it unmistakably clear in that non-modification provision that they agree that maintenance will survive the recipient spouse's remarriage and that maintenance is not subject to the automatic termination under 1410-122A. The court also held that this particular separation agreement did not use sufficiently clear language and that the parties could not have been found to have agreed that maintenance would survive the recipient spouse's remarriage. So even under the law as it was before today, our client's maintenance obligation would have terminated automatically under 1410-122-2A when his ex-wife remarried. Ultimately, the court reversed the decision of the trial court here and ordered not only that that our client's maintenance obligation terminated upon his ex-wife's remarriage a few years ago, but also that all of the maintenance he's paid since that remarriage be reimbursed to him. In doing so, the Court of Appeals effected a sea change in Colorado law regarding the way separation agreements will be drafted and interpreted. We suspect that many family law attorneys today are likely viewing their cases in a new light in evaluating whether their clients are obligated to continue paying spousal maintenance based upon the terms of the separation agreement. Again, this is a big win for our appellate division and an even bigger win for our client, for whom we're very happy.